All right, good evening, everyone, and welcome to our latest educational session, Medicaid and Asset Protection. I'm Mike Hebron, the Chief Operating Officer and one of the partners here at Level Financial. And I want to thank everybody for taking the time out of this beautiful summer-like day here in Buffalo, if you happen to be here locally. We're happy to have with us tonight Sarah Fenster of Fenster, Lewis & Good LLC, attorneys at law. And in a moment, I'm going to introduce Sarah. But first, before we start, just a couple of ground rules for tonight's webinar. First, we have all participants muted to reduce distractions during the presentation. So all attendees do have the ability to raise their hand, and we encourage you to raise your hand using the features at the bottom of the webinar or to submit questions via the chat feature of our webinar software, and we'll hopefully be able to answer those questions either during the presentation at advantageous moments where we can pause or at the end. And if there's a very, very specific question that is specific to your needs, we will have a way for you to get those questions to Sarah so that you can have a more in-depth conversation with her. We'd like to allow for questions at the end as well. So if there's something that you're thinking of that you want to have answered at the end, feel free to use the chat function for that. The webinar is being recorded, and we will send a link out to all the participants with the recording. Usually we like to get that out within 24 hours. Finally, if anyone wants to speak directly with Sarah about their specific situation, we've set up our text line at 716-727-5047. And if you text the word Medicaid to that number, we will get some information over to Sarah, and she will reach out to you and follow up with your questions. Before we get started and I introduce you to Sarah, I just need to go over a couple of disclosures that we have to do for any type of these webinars or educational sessions. First, Level Financial is not a law firm nor an accounting firm, and no portion of our services should be construed as legal or accounting advice. You should not assume that any discussion or information contained in the presentation serves as the receipt of or as a substitute for personalized investment advice from Level Financial. And of course, past performance may not be indicative of future results, so different types of investments involve varying degrees of risk. We say this during all of our presentations. It should not be assumed that future performance of any specific investment or investment strategy, including the investments or investment strategies recommended or undertaken by Level Financial advisors, or any non-investment related content will be profitable, equal in any corresponding indicated historical performance levels, be suitable for your portfolio or individual situation, or prove successful. So those are our required regulatory disclosures for the presentation. And now I'd like to introduce tonight's speaker, Sarah Fenster. Sarah, there she is. Hi, Sarah. Sarah graduated from the State University of New York at Buffalo Law School in 2014. And while at UB Law, Sarah was an editor of the Buffalo Law Review and the publication editor of the Buffalo Journal of Gender, Law, and Social Policy. Sarah joined Fenster, Lewis & Good in 2016 after spending her first 2 years of legal practice as a commercial litigation attorney. Sarah serves on the board of directors of the Rising Champions of Justice with the Volunteer Lawyers Project, and she's an active member of the Women Lawyers of Western New York. Sarah's practice focuses mainly on estate planning and trust and estate administration. And so without further ado, here is Sarah Fenster.
All right, good evening, everyone. Thanks for joining us today. So I am going to try and cover a lot of different topics and a bunch of information over our short time tonight. Just as a caveat before I do get started, a lot of Medicaid planning is extremely fact-specific based on the personal and financial circumstances of our clients. So I'm going to provide some very broad information, But like Mike said, if you have a question that's very specific to your circumstances or a very unique situation, please feel free to reach out to me separately and we can dive into that in a lot more detail. So if we look at our agenda here today, these are all the different topics that I'm going to be covering, and we'll just dive right in. So the first thing that people always talk to me about is, what does a nursing home cost these days? And unfortunately, more and more of us are learning that nursing homes are extremely expensive. Nursing homes are often $400 or $500 per day. So it very quickly adds up to extremely high bills of over $14,000 per month. So right off the bat, a lot of my clients come to me and say, I've saved my whole life and paid off my house and have this great savings account or investment account, and I can't fathom spending all that money so quickly by paying for nursing homes. So there's really three ways to pay for a nursing home. First is long-term care insurance. Long-term care insurance, for various reasons, has become more and more difficult to obtain. So some of my clients purchased policies years ago and have these amazing benefits, but those are not nearly as common. Other clients can't obtain insurance because of, health factors, or it's just not financially feasible for them. Some people also have partnership policies, which you can't get anymore, but a partnership policy is a special arrangement between the long-term care insurance company and New York State. And I'll talk about that in a little more detail in a few minutes. Then, of course, you can just private pay the nursing home, and that would be at whatever the cost is, the $14,000 or whatever per month. And then the final option there is to have Medicaid cover. So if Medicaid covers the nursing home bill, the nursing home resident usually has some sort of liability themselves to pay a portion of their income, but then Medicaid picks up the remaining bill. So that's our goal here is how can we qualify for Medicaid? We don't have long-term care insurance. We certainly don't want to pay the private pay rates. So let's take a look at this Medicaid option, because for a lot of people, that's the way they want to have these costs covered if they ever end up needing to go to a nursing home. So if we look at Medicaid eligibility, there's a few different factors that Medicaid looks at. First, they look at your resources, and second, Medicaid looks at your income. So for resources, that includes certain cash assets, like cash in the bank, the cash value of a life insurance policy, non-retirement investments. It also includes the value of real property. So I just have all those listed there. Then we also have the resource limits listed here. So this is how much money you're allowed to have and qualify for Medicaid. So if you are a single person, which includes a widowed person, if your spouse has passed away, you're allowed to keep $15,900. So it's pretty low. I mean, you have to really appear to be poor in order to qualify for Medicaid. And then if you're married, your spouse who still lives in the community, so the non-nursing home resident spouse, is allowed to keep somewhere in that range of about $74,000 to $130,000. And that's a calculation based on how many assets you have, or the total value of your asset at the time of the Medicaid application. There's also some exemptions for a community spouse. So if you are single, I'm going to back up for a second. If you are single, you do not get to keep a house because you're not living there anymore. You don't get a vehicle because you don't need it anymore if you're living in a nursing home. And then you can only keep a very small amount of your resources. That's the $15,900 limit there. If you are married and your spouse is living in the community still, your spouse gets to keep a certain amount of his or her cash assets. That's the $74,000 to $130,000 figure. The spouse also gets to keep the residence because they need somewhere to live and a vehicle. Then we look at income. So a very important note here is that a retirement account, like an IRA or a 401k, is not considered a resource. So the value of a retirement account does not come into play when we're calculating how much money someone has and whether they are underneath those resource limits. However, a retirement account is considered an income source. So if you were to apply for Medicaid, Medicaid would look at that retirement account and they would do a calculation on what amount you should take out of that account on an annual basis. It's very similar to the required minimum distribution that the IRS requires. However, Medicaid gets to make up its own rules, and usually the percentage that you're required to take out is a little bit higher than the IRS RMD percentage. So just to keep that in mind. The other sources of income include wages. So if a spouse in the community is still working, that wouldn't be included as the income. Social Security, I didn't put this on here, but obviously pension, if you're getting annuity payments, anything like that is all lumped together in as your total income. And in order to qualify for Medicaid, your income has to be less than the medical expenses. So if someone gets, this would be someone who's quite wealthy, but $20,000 of monthly income, they're not gonna be able to qualify for Medicaid because their nursing home bill is going to be less than their monthly income. And then there's income limits. So the nursing home resident, this sounds crazy, but only gets to keep $50 per month of their monthly income. So again, if you are single, you get to keep your $15,900. You can keep your retirement accounts, knowing that you have to pay a certain amount on a monthly basis as income, and then you get to keep $50 per month. The remaining income over the $50 per month is paid to the nursing home, and that is called your NAMI, N-A-M-I, your NAMI. And then Medicaid, so after you lump together all your income, keep your $50, the rest goes to the nursing home, and then Medicaid picks up the difference. And then if you have a spouse, so if you're married, your spouse in the community, he or she gets to keep up to a certain amount of his or her monthly income as well. And then if there is an amount over that, they may be required to contribute some of their excess income towards the institutionalized spouse's NAMI, their payment to the nursing home. So as you can tell, before I move on, qualifying for Medicaid is a numbers game. And when I meet with clients and they tell me, oh yeah, I have a bank account, it's probably like $20,000, and I have an IRA, I forgot what the balance is, you got to talk to my financial advisor, and I might have savings bonds out there. That it's impossible for me to give them an answer on whether or not they could qualify. It's extremely specific. And when you apply for Medicaid, as many of you have probably heard, and I'm going to dive into right now, there's a 5-year look back period. And all that means is that Medicaid will require 5 years of financial statements, going backwards from the date of your Medicaid application. And they're going to comb over those statements very, very carefully to see if they find anything that looks suspicious, see if you've transferred a bunch of money out of your name or done anything else that reduces your resources so you could try and qualify for Medicaid. So my point is, when you're doing any sort of Medicaid planning, whether it's with me, a different attorney, or whoever, it's important to be extremely specific on what you own. Because if you forget about an asset or overlook, an account or savings bonds or whatever, that could have a real negative impact on the overall plan. So when I meet with clients and they want to try and qualify for Medicaid, but they have too much money for their resources, there's some options to do ahead of time, and that's the pre-planning. So that's where the 5-year look back period comes into play. What's very important to have in place is a good power of attorney. So again, some clients have a power of attorney, but it's 30 years old, it's on an old form, addresses and names have changed. And while that's still legally valid, it's always a good idea to just have a very current power of attorney that has all of the bells and whistles that are included on the current forms through New York State. So before we do any Medicaid planning with clients, I always make sure they have a power of attorney in place. Because let's say we start the Medicaid planning, but something happens, then your power of attorney can always step in and complete the plan by signing on your behalf. And this is what I just started talking about, the 5-year look back period. So that's when Medicaid collects all of your financial statements for the past 5 years, and they're looking for any transfers or gifts within that 5-year period that you've done for the purpose of qualifying for Medicaid. And they're going to deem that any transfer where you haven't received something in exchange for that money is a gift in order to qualify for Medicaid. So common examples would be, maybe paying for a grandchild's college. You gave them $10,000 for college. That is a gift. You gave away your car to a grandchild. Happens actually pretty frequently. That's considered a gift. Now, they're not looking at every last penny. Typically, counties have kind of a dollar amount where they only look for gifts over that dollar amount. That's not in the law, that's not even in the regulations. It's just kind of like their practice. So in Erie County, they typically don't review gifts that are under $2,000. However, if they see a pattern, they could certainly catch on and consider those gifts. But if it's a one-time $500 gift to, whoever, they may not catch that and they may not, care about that. In Niagara County, I believe it's a little bit less. They may review things that are like $1,000 or less. So if there's these if there's these gifts or transfers, Medicaid, the caseworker will add up all of these transfers and say, you know what, if you would have kept this money, you would have qualified, or you would have been able to pay for your own care, and you're not going to immediately be eligible for Medicaid. And they give you this penalty period. And the penalty period is calculated based on the total value of the gifts or transfers that you made during that 5-year period. So if you made approximately $10,000 worth of gifts, they're probably going to give you a 1-month penalty period. So they say, all right, after 1 month, then we will kick in and Medicaid will start covering your nursing home bill. We have clients who give a lot of gifts, and they may have a 2, 3, 4, 5+ month penalty period, and that can be really problematic. So again, to be a broken record over here, if you're doing Medicaid planning, it's extremely important to be open with whoever's doing it with you on whether you've made gifts or transferred things out of your name within the past 5 years. So if we're looking at pre-planning options, that includes making gifts, includes doing a life estate deed, or doing a type of a trust. So all 3 of those come with different benefits and negatives, I guess you could say. So gifting is just what it sounds, giving away your stuff. It's simple, doesn't require a lawyer. You could literally just write a check for, whatever amount to one of your kids. And there you go, you've moved something out of your name. It would only be effective if 5 years passed after you wrote that check, 5 years before you apply for Medicaid. But it still works for reducing your resource level. The downside to that is you've just given away your money. So if you needed it in the meantime, or if anything happens and you want to have access to it, that no longer works because you've given it away to someone else. So a lot of clients who want to accomplish the idea of a gift, but still want to maintain some control over that asset, use one of these other tools, either like a deed or a trust, to do the same type of thing. So the first thing is a life estate deed, and this works to protect real property. So a lot of clients may have, as a simple example, some nice retirement accounts, and maybe they have, or they have a good pension. So neither of those things are resources. An IRA is not a resource, and a pension is just an income stream. So maybe they don't have a lot of cash assets that are necessarily at risk for Medicaid purposes, but they have their house, and their house is valuable, and they want to make sure that they can protect their house. A life estate deed is a very simple tool to use to both protect it, and a little added benefit, which is not the topic for today's conversation, but it also avoids probate. So if they pass away, the house does not require a court proceeding in order to be transferred to their beneficiaries. So for a life estate deed, the owner adds other people to the deed as beneficiaries. So I typically refer to it as the parents and the children because that's the normal arrangement, but it could work in a variety of other circumstances as well. It could be someone adding nieces and nephews to a house, or a friend to a house. It doesn't have to only be parents and children. So when the owners add these other people to the house, mom and dad add their children to the house, they're not just giving away their house. People casually refer to, I gave my house to my kids. That's not really what's happening. What they're doing is adding their kids to the deed, but the parents or the original owners retain what's called life use of the house. That's why it's called a life estate deed. They have a life estate in the house. And that means that they continue to use and enjoy the house just like they do now. So they have exclusive use and occupancy of the house. Because they retain that benefit, you also retain kind of the burden of home ownership. So you're still responsible for the taxes, you're still responsible for the upkeep and all sorts of things like that. However, you have these other people on the deed. So if you do want to ever sell the house, they're involved and they have to sign off. So they have to sign the contract for the sale. They also have to sign all the closing documents. So if someone comes to me and says, I want to protect my real property, but I'm probably going to downsize next year, depending on the circumstances, I would likely say, all right, let's hold off. And if you're going to buy a new house next year, maybe we do the life estate on the new house. Obviously, that's subject to a lot of caveats. Maybe the circumstances are different. We want to get the life estate in place right away. But typically, it's much easier to put a life estate on a property if it's someone's kind of long-term, permanent, like retirement home situation. Because once the house is in life estate arrangement, now your kids are involved in any transaction, it just becomes messy. Also, if I've noted here, shouldn't have gone forward yet. Also, I noted here that if the house is sold, the beneficiaries or the children are also entitled to a portion of the sale proceeds. And again, some people kind of say, wait, what? If I sell my house, my kids get my proceeds? And that's exactly the way it works. So if mom and dad put, however many children on the deed with them, and they sold the house while it was in a life estate arrangement, mom and dad's percentage of the proceeds is actually based on their life expectancy. So the older that mom and dad are, the less, the lower or smaller percentage of the proceeds they will be entitled to. And then the children or the beneficiaries on the deed receive the rest of the proceeds. That doesn't mean that the children can't turn around and give the proceeds back to mom and dad. But it's certainly, an added consideration if someone was thinking about doing a life estate deed. All right, then I have an asset protection trust. So an asset protection trust is a more complex way to protect financial assets and or real property. Because it's more complex, it also has a lot more flexibility. So if someone comes to me as a simple example and wants to do a life estate deed, however, it's not as simple as them just listing, a few children on the deed. They want to list their granddaughter and have, and she's a minor, and they want, their child to manage the proceeds from the sale of the house for their granddaughter for her education. That is way too complicated to go on a life estate deed. Life estate deeds are great, but they also have limitations because it's a simple deed. You can't outline all these different rules. So that's where trusts become very helpful. Trusts are also the only way outside of just gifting things away to protect financial assets. So that's where you could protect savings accounts or cash value of a life insurance policy or an investment account or stock or whatever it may be. So in an asset protection trust, you have to have a trustee. And there's other types of trusts that don't provide protection that are less strict and allow more flexibility for the people creating the trust. But in this case, there has to be some very specific rules in place for Medicaid to deem that the trust effectively is protecting these assets. So the first thing is you need a different trustee. The people creating the trust, like the parents, cannot name themselves as the trustees. So that's where we typically see a child or two stepping in to say, all right, mom and dad, I will be your trustee and help you set up this trust for asset protection. Just because someone is a trustee doesn't mean they have kind of unfettered access to the trust assets. They're still bound by the trust rules, but it certainly has to be someone who is trustworthy and someone who the parents can work with on a regular basis to manage these assets for them. An asset protection trust must be irrevocable, which means that the parents or the people setting up the trust can't simply say, I've changed my mind, I don't like this, give me all my assets back. They cannot do that. There is a very strict rule that's found throughout these trusts that says principal from the trust cannot be distributed back to the grantors or the people creating the trust. And that is absolutely necessary for this type of trust, because if that provision was not in place and you applied for Medicaid, the caseworker would simply say, not as informal as this, but they would say, why don't you just take your stuff out of your trust and pay for your nursing home care, and then we'll talk. They're not going to allow you to have direct access to this pool of wealth while still receiving, Medicaid benefits. So that's why the trust must be irrevocable. And the grantors, the people creating the trust, cannot have the ability to just go into the accounts and take out money or whatever whenever they want it. However, with all that being said, it sounds kind of negative so far. The grantors, the people creating the trust, do have a level of control and are able to alter or amend different aspects of the trust. So first of all, you can have control to distribute assets out of the trust at any time, just can't go directly to you. So you could say, all right, well, if I, let's say I want to go on vacation with my kids and I want to use my trust money, I could just have my trustee give some money to one of my kids and they could buy the airfare and the hotel and all that good stuff. So you still have the ability to kind of use the money, but it has to be through a third person. You can't take it back in your name and use it. You could distribute it out to someone in a class of people that you've designated. And usually that's, children and grandchildren and people like that who you can distribute money to. So that's a powerful tool to use. You also have the ability to change where the trust goes when you pass away. So the trust will have its standard default provisions that'll say when the grantors, the people creating the trust, pass away, this is what happens to the trust assets. But then down the line, if you say, circumstances have changed and we don't like those default rules, you can do a simple amendment to the trust and alter the way that the trust is distributed at death. So that's a very powerful tool as well. And then finally, you can always change your trustee. That's another thing that you want to be able to change. If things go sour with whoever you've chosen as your trustee, you have the ability to replace them with someone new. All right, I'm going to go back for a second and keep talking about trust for a minute before I move on to crisis planning. So when you set up a trust, and people sometimes have confusion over this, a trust is just a set of rules. It's an agreement, paper. The agreement between the people creating the trust and the trustee who's managing the trust. And then a trust is an entity. It has its own tax ID number. And then the trust can go and open accounts and own things. So typically what happens if the trust is protecting money, the trustee would go to a financial institution, bank, wherever, and open an account in the name of the trust. The trustee is the one that has the authority to sign on behalf of the trust. So if it was a checking account, it would be the trustee's signature on the checks, things like that. And then the grantors, the people creating the trust, then just move money into that new trust account. So if the trustee opens a bank account or an investment account, and then mom and dad, the grantors, say, all right, we want to move over $100,000 and put it in that account. They move the money into the new account. And the date that the money leaves the parents or the grantor's account and goes into the trust account, that's the day that the 5-year look back period starts. And that's important to note because that could happen, a few days, a few weeks, a few months after the trust is created. So we always counsel our clients on next steps and, how to get things done in a timely manner. But just because you create the trust, that's not the magic date. Creating the trust is step one. Having the trust own things and transferring things into the trust, those are the dates that are important for the 5-year look back period. Now, if you wanted to transfer property to a trust, that would be a deed. And it would say, the deed is being transferred from, mom and dad or whoever to this, asset protection trust. And so is the trustee. And then the deed is recorded with the county clerk's office for whatever county the property is located. And the date that deed is recorded is the special date for the property. So it's just important to keep that in mind when trust planning is happening, depending on circumstances or age or health of our clients. Sometimes these things do have to happen in a pretty quick manner in order for that 5-year period to get started. Okay, so I just talked about pre-planning. So that's just giving stuff away as gifts, doing a deed or a trust. Now, unfortunately, we see a lot of clients who kind of miss the boat on pre-planning, and maybe they're on their way to a nursing home or know that they need nursing home in a very short period of time. So in that case, we kind of abandon these options because you don't have the ability to set up a trust and protect assets 100%. In that case, we have some last minute crisis planning techniques. So these are things we talk to clients about. Like I said, if they come to us and say, mom's going into a nursing home next week, what can we do? Unfortunately, well, I should say, fortunately, there's options. Unfortunately, you're not able to protect as much of the assets with these last minute techniques. So first, you can spend down on exempt assets. So that just means there's certain things that you can pay for last minute that are not considered gifts for Medicaid. So it won't be a negative on your Medicaid application and won't go towards the penalty period. So a few examples of that: if you have a spouse, they get to have a house and they get to have a vehicle. So maybe someone's leasing a vehicle, you could just buy a car. It seems silly, but it's a way to protect some money if you have too much. You can also prepay for your funeral, your burial. That's something that most of our clients do when they're in this circumstance. And in certain situations, you can also prepay for certain family members' funeral and burial. So again, that's a great way to kind of get some money out of your name. You don't get to keep it, but at least you haven't given it. You don't have to pay towards your nursing home care on it. You've paid for something beneficial for your family. There's also certain situations where transfers can be made to disabled children or caretaker children. So a caretaker child is someone who has lived with you for a period of time prior to the Medicaid application for the purpose of caring for you. And there's ways to protect real property if that person has lived with you. So maybe, a child has moved in with mom for, several years, and then the child just couldn't take care of her anymore. So mom needed to go to a nursing home, but the deed of the house is still in mom's name. If you can prove that that child was a caretaker for that period, the house could actually be transferred to the child without it being at risk for being spent on the nursing home care. So those options, while somewhat rare, can be helpful in the right circumstances. And then the last thing I want to talk about is a technique that's used that involves a promissory note and a gift. And this is, again, very number fact specific, and sometimes drives us crazy when we come up with these calculations, because you do need to know everything down to the penny. But it can be very, very useful in protecting assets when someone has a large amount of money and they're going into a nursing home. Oops, I thought another bullet point on that. So the promissory note and the gift technique works like this as a simple example. If I'm going to use a single applicant as an example, but if a parent needed to go into a nursing home and they had $100,000 in an investment account. And because I'm creating this example, I'm going to make everything work out really simply, but let's say they had another $15,000 in a bank account. So based on the limits we looked at before, that parent can keep the $15,000 in the bank account. And we're going to pretend they don't have any other cash assets, like there's no life insurance, no savings bonds, none of that. And let's say that the parent also doesn't have any real property. So they were renting an apartment or something at the time. So they get to keep that $15,000. That's easy. But that $100,000, that's a problem. They are well over the Medicaid threshold for resources. And we can also spin out some facts on the income, but it doesn't really matter. Let's say she has a few sources of income, and those will have to go towards her bill, and she'll get to keep her $50 a month. Okay, so that's kind of the income. We'll just pretend that all worked out fine too. But for purposes of that $100,000 in that investment account, that is completely at risk. So what you can do is do a combination of a promissory note and a gift. And what happens is mom would gift, it's usually approximately half of that at-risk amount. So if we're using 100,000, let's say she gifts 50,000. And because she's doing a gift right before she goes into a nursing home, that's going to create a penalty period. So that's when Medicaid would say, all right, you made a gift. If you would have kept that money, you would have been able to pay for, let's say, 5 months of your care in the nursing home. So we're going to give you a 5-month penalty period. And in month 6, Medicaid will start paying your bill. And then in the meantime, the other $50,000 of the $100,000 is going to be loaned to a child. And magically, after we crunch all of our numbers, it works out where over that 5-month period, the child is going to repay mom that loan. And for those 5 months, the loan repayment amount is going to cover her private pay rate until month 6, when the nursing home bill is now going to be paid by Medicaid. So even when I use that simple made up example, it's complicated. It's hard to sometimes, if you're not familiar with all these rules, to wrap your head around, like, how does that work? I give a gift and then I loan it and somehow I make it to month 6, but it can be an extremely powerful tool. Again, it requires precision with what exactly is the nursing home bill, what exactly are the income sources, how much money are we over, but is a great, great tool. So I always tell clients, even when we do the pre-planning for 5 years, no one has a crystal ball, and maybe you don't get through the 5 years. Either something unexpected happens, or we're doing the 5-year plan when our clients are quite old and we're not sure if we're going to make it through the 5 years. This is always a backup plan. If we put a trust in place, but we don't get through the 5 years, we can usually take a step back. And I'll put this note and gift technique in place. It does not protect as much of the assets, but it certainly protects something. Now, in that same example, if mom would have done some pre-planning 5+ years ago, she could have moved that entire investment account into a trust account. And if she had done that, she would have protected the whole thing. So if we're comparing pre-planning to crisis planning, if you do good pre-planning, you can sometimes protect double than what you would do with crisis planning. So I always tell people, they ask me, like, when should I start thinking about this? You can start thinking about it as early as you want. I think when people are starting to consider retirement and they're starting to look at what their long-term needs are in terms of how much do I need for what's my income going to be every month? Do I need extra? What's in my investments? What do I really envision needing? What is truly savings that I'm earmarking for my kids? That's a good time to start thinking about nursing home pre-planning. And that is also a conversation you have with your financial advisor, because they're the ones that are going to be figuring out how much income do you need? When should you retire? What do my investments look like? So we rely very heavily on the other professionals working with our clients to come up with a good game plan for the pre-planning. How much can we move into a trust and allow our clients to remain comfortable? Things like that. But anyways, I think the best time for someone to put a trust in place could be, late 60s, early 70s. We typically expect during that age to have a 5-year window without 5-year period pass without a concern. And usually at that point, there's no issues of like capacity. People are fully capable of putting these plans in place. But I've done pre-planning with people that are significantly older than that, depending on circumstances. So for whatever that's worth, that would be kind of my general recommendation. And then the last thing I just wanted to touch on is community Medicaid. So this is Medicaid that covers aides to come to your home while you still live at home. There's also community Medicaid that kicks in at assisted living facilities. So this is becoming a little bit more popular. People, of course, would prefer to stay home longer rather than go directly into a skilled nursing facility. However, there's a lot of limits on the way that you can receive care in this manner. There's a lot of rules regarding like what type of assistance you need. You need a certain level of assistance in order to qualify, but you can't need too much assistance, or it's really outside of the scope of staying at home. So Medicaid has kind of their process to review, an applicant's medical needs, and things like that, which I am not involved in. So I can't really speak to too much detail on that. But there's a review process on Medicaid side to make sure that an applicant is appropriate for at-home care. And then these are also the types of programs where people can have their family members be their own aides and get paid through Medicaid. So there's a lot of programs out there, and they're kind of popping up more and more because of the preference for people to stay home. And honestly, because too many people need to go into nursing homes. So we're trying, the whole industry is trying to come up with different ways to slow the admission to nursing homes, because there are so many people that are starting to require nursing homes right now. And then I've just put a note here that currently, right now, there is no look back period for community Medicaid. So in theory, if you wanted to apply for community Medicaid next month, you could move everything out of your name in order to qualify this month. However, there is a 30-month or 2.5-year look back period that is going to be implemented. It was supposed to be implemented in the fall of last year, and it keeps being pushed out. And we're still not sure. I spoke to a social worker who worked on Medicaid applications earlier this week, and she told me she thinks that it's not going to be implemented until next year. But don't quote me on that, because no one really knows. But anyways, just to keep that in mind, that if you are doing pre-planning for a nursing home, expecting there to be a 5-year look back, you could indirectly also be doing some planning for community Medicaid, which has a shorter look back. One final thing to note is that clients always ask me if the look back period is going to go up. Some people think it already went up in 7 years. We have no idea. There's always chatter of the period being increased, to 7 years, or even something, much longer than that. But until something is coming down the pipeline, we're going to continue to plan, expecting there to be a 5-year period. And worst case scenario, if the period gets increased when they've increased the period, they've grandfathered in prior planning. Or, if they increase the period, that's just stronger motivation to try and get this done as early as possible, so you can protect as much as you can. So this is my last slide. And I'm just going to take a sip of water, and then we can start answering questions. I've seen some flashing up on the chat box, so we'll see what questions people have.
Okay, so great. Thank you, Sarah. That was very, very informative. I've got a few questions here that came through, and we'll preface this too, that if the questions are too specific, we can just say that now, and then we can try to get a hold of the people that ask the question if it's, if it gets into too much detail for a specific situation. The first question here is, I have long-term care insurance, but my wife doesn't. What are my liabilities if she has to go into long-term care? What assets are protected and which are at risk? And they also mentioned too that they have a pension, and would that be at risk?
Yeah, so unfortunately, in this situation, if the husband needs nursing home, great, there's long-term care insurance. If the wife needs a nursing home in this case, all of the same Medicaid rules would apply. So what's at risk? The wife can keep the $15,900, and husband can keep between the 74 and 130,000. And then the income, wife would be able to keep her 50, and then the husband would be able to keep the 3,000 number. And if husband had, the pension that's mentioned here, if that's more than the limit on income, may be required to contribute some of that excess towards the wife's nursing home bill. So in a case like this, there could be some planning opportunities to try and set up a trust or some other ideas to kind of avoid that scenario with wife. We also have clients, not to go off on a tangent, we have clients who a spouse may qualify for a veteran's benefit. In Batavia, they have the nursing home, and that could be a similar situation. So one spouse has kind of a plan for their long-term care, but the other spouse doesn't. And there are some techniques to use to how to title assets and keep things separate to anticipate those types of problems.
Okay, great. The next question that we had here is, it says if an I bond was purchased November 2010 with co-owners and gifted to the co-owner in 12/2015, does the co-owner have full rights to it? The future Medicaid recipient name and Social Security are on the bond.
Okay, I'm going to read this again and make sure I
Yeah.
understand the situation. So the bond was purchased in 2010 and it was gifted from one co-owner to the other in 2015. Does the co-owner have full rights to it? So a future Medicaid recipient name and Social Security are on the bond. So if the Medicaid recipient was the one who gifted it to the other co-owner, and it was done in 2015, that is outside a look back period. So it would be protected for the Medicaid recipients, circumstances with Medicaid. If it was gifted, I guess I'm confused why the name and Social Security are still on the bond, because typically that would be retitled in the other co-owner's name through, Treasury Direct or some other arrangement like that. So that might be one where I may have gotten the circumstances a little confused when I'm deciphering it here. So that's my initial answer. And if I don't understand the situation, I'm sorry, and we can talk offline about that.
Okay, great. The next question, this is an interesting question when we're talking about look backs and values of assets. The question is, how are possessions viewed? Things like jewelry and art and furniture and et cetera.
Yeah. As of right now, Medicaid does not care what you own, and they don't really have a way to find that out because it's not reflected through, a bank statement or anything like that. Typically for most people, unless you have an unusually valuable personal item, personal items are usually pretty low value, furniture, clothing, stuff like that, that doesn't have an innate value, but even jewelry, things like that, Medicaid is not asking about that right now. And I guess they would have no way to track if you gave it away or anything like that either. So we do not worry about personal items.
So obviously, just to follow up on that, from my personal curiosity, obviously, if somebody went out and bought a large amount of jewelry during the 5-year look back period, that would be considered something that would be looked at, right?
Yeah, I mean, I've never specifically dealt with that scenario, so I don't know how they would deal with it. Now, that's not a gift because you got something for it. But I don't know in that case if Medicaid would say, how did you just spend $100,000 at, sales or whatever? And I don't know how they would handle that, to be honest. They've never dealt with that situation.
Okay. The next question here is, you had indicated that long-term care partnership plans were no longer being sold. Are current partnership plans grandfathered?
Absolutely. If you have a current partnership plan, it absolutely still is effective. And I think I promised that I was going to talk about partnership plans and then I didn't. So I can talk about those for a minute now. A partnership plan, for those who are unfamiliar, is an arrangement between the long-term care insurance company and New York State, the Medicaid. So it says that if the partnership policy pays for the nursing home for X number of months or whatever the period is, then immediately after that long-term care policy ends, let's say it's for 2 or 3 years or whatever, then New York State will automatically allow that person to go on Medicaid. And that's effective even if that person still has, tons of assets in their name. It's an automatic Medicaid acceptance. So that's why those policies are no longer offered, because they're awesome and they provide this great, they're expensive, but they provided this benefit and then an automatic way to get onto Medicaid, even if you've accumulated a pretty significant wealth in your name. So the answer is yes, they're grandfathered. If you have one, don't get rid of it. But unfortunately, you can't get them anymore.
Okay, and we have another question here. Can a prenup for a late in-life marriage protect one spouse's assets if the other spouse needs long-term care?
Okay. So for a prenup, if someone got married, I guess it doesn't matter when in life, but especially for someone who's older and has a prenup for a later marriage, would kind of show whose assets are whose in case of a divorce, and oftentimes has information for when they pass away For Medicaid purposes, that would not be a way to protect their assets. However, one thing I didn't mention in my presentation is a spouse can always refuse to support their other spouse. So if Medicaid says, hey, you should really contribute X amount of dollars towards your spouse, there can be a spousal refusal. So in a case like this, they could go down that path where they refuse to support their spouse when the spouse needs to be institutionalized. However, always a caveat, New York State could technically sue the spouse who is refusing support to try and force support. Historically, Medicaid would not do that, but we've actually seen a few cases in the past few years that have popped up and haven't totally been resolved. So we're not sure kind of if that's even a good option for people anymore. But in a case like that, or in other very specific circumstances where one spouse has significantly more wealth than the other, that could be a path that we could at least consider, weigh the risks, and something, one way to try and protect some assets for the wealthier spouse.
Okay, we have another question here. Regarding money given as birthday or Christmas presents to children and or grandchildren, would Medicaid consider that a gift subject to the look back?
The answer to that is it depends on the value. So if it's like a standard, I don't know what grandparents always give, but if it's a standard, $100 for Christmas or whatever, Medicaid's not going to bat an eye at that. If a grandparent is being especially generous and giving larger sums, that's when it would become increasingly risky that Medicaid would take a look at it and include it in the penalty period. I've had people ask me to kind of piggyback off that question. I'd like to contribute to my granddaughter's wedding. Like, how should I do that? And first of all, I don't like whatever the phrase is, the Medicaid tail to, wag the dog, whatever, but I don't want Medicaid to dictate how everyone leads their life. But at the same time, if we're doing Medicaid planning, I appreciate clients asking me those questions. So, in a circumstance like that, you may want to give a larger gift over a period of time. So it's smaller gifts. So it's not as obvious that you're giving something away.
Okay. Another question. Is a Roth IRA treated just like a traditional IRA for Medicaid qualification purposes, even though a Roth IRA doesn't have required distributions?
Yes. All that would have to happen is it would be paid out based on the schedule that Medicaid applies. So even though the IRS doesn't have required distributions, Medicaid does, and you would just apply it the same way and pay it out monthly, and then it would be applied towards the NAMI amount towards the nursing home. So it's the underlying account still protected. Okay,
great. At this time, we don't have any further questions. If you advance that slide one, Sarah, I think your contact information is on there for people to see if they want it. And then I want to encourage people to, if they want Sarah to proactively reach out to you, or if you want us to reach out to you, just text the word Medicaid to our text line, which is 716-727-5047. You'll get an automatic response to that, but then as soon as we get it, we will make sure that we forward that information on to Sarah, and then she'll reach out to you. So with no further questions, I just want to first of all thank Sarah for a great presentation, and thank you for coming in on this beautiful day, and thank everybody for attending this educational session. Have a great night.